Judge Merchan to present jury with instructions ahead of deliberations in NY v. Trump trial. Judge Juan Merchan will present the jury with instructions Wednesday as they head into deliberations into former President Trump's New York criminal trial. Manhattan District Attorney Alvin Bragg charged Trump with 34 counts of falsifying business records in the first degree. Trump has pleaded not guilty to all counts. With the end of former President Trump's criminal trial in sight, a pending verdict in the historic case could have serious consequences in the 2024 election rematch between President Biden and the former president, who currently has a slight edge in polling. But with a potential conviction looming, veteran Democratic pollster Chris Anderson told Fox News that he didn't think a guilty verdict would fundamentally change the landscape of the race. Longtime Republican pollster Neil Newhouse went even further, arguing that a Trump conviction is unlikely to make any difference. We might see an Access Hollywood-type slump in Trump's poll numbers, where some of his less devoted supporters sour on him temporarily. But then by November it will seem forgivable, Anderson said. So I don't think a guilty verdict would fundamentally change the landscape of the race, but it will certainly be a new contour that could be meaningful in a close race. Andrew McCarthy from outside the court. Jury could be confused about campaign expenditures. It seems to me that this phrase would not have been paid, but for the campaign from the prosecution, is confusing in a pernicious way. It's really more of a legal concept than a factual one. That is, categorically, NDA are not campaign expenditures because they are obligations created independent of the campaign. In other words, Stormy could have pressured Trump to pay up in contexts having nothing to do with the campaign. But what the jury is being told is that but for the campaign is more of a fact question than a legal question. That is, if Trump or Michael Cohen would not have paid Stormy if it weren't for the campaign, then it becomes a campaign expenditure. In reality, the campaign may have been Trump's motivation for paying up, but technically that doesn't make the NDA a campaign expenditure. And as a matter of law, if an NDA is not technically a campaign expenditure, then it shouldn't matter what his motive was. Jeanine Pirro and Lydia Hu inside the court. What to watch for during jury instruction. We can watch for the judge's instruction relating to the Federal Employees Compensation Act. One theory advanced by prosecutors is that documents were falsified to conceal an illegal campaign contribution in violation of FECA. From the 521 transcript, here's what each side requested. Prosecution request. A candidate for federal office does not have to be the sole or only motivation for the third party's payment, so long as the payment would not have been made but for the candidate's status as a candidate for federal office. Defense request. If the payment would have been made even in the absence of the candidacy, the payment should not be treated as a contribution. Merchan reserved on his decision but indicated he was leaning toward including both sentences, which seems good for Trump. We will find out today how he handles in the jury instructions. If jurors believe that payment for the Daniels NDA would have been made even if Trump was not running for office, BC Trump was concerned about harm to family, business, reputation, etc., then that payment cannot be treated as a campaign